reiterate our commitment to struggle and celebrate the end of dark times, we can see a ray of hope in our honorable speaker. I invite President of PUCL, Jayaprakash Narayan.
Good evening, everybody. I welcome all of you once again on behalf of the National PUCL to this 45th memorial lecture which we do every year in the name of Jayaprakash Narayan. Since there's several young people, let me tell you why we do it. It's actually done on the 23rd of March, but due to date adjustments, we moved it to the 30th. But why the 23rd of March? 23rd is remembered for several reasons. It's the Shahadat Day, Martyrs Day, Bhagat Singh. But it's also the day when Indira Gandhi, after having lost the elections in 1977 on the 16th of March, signed away the emergency. Now the emergency has been withdrawn. But that was done on 23rd. Many so in a way, this human rights movement is 50 years old. In 1976, it actually, formally born. So we are in our 50th year. It was envisaged by Jayaprakash Narayan as an organization where all those committed to the defense of civil liberties and democratic rights, whatever be their political ideology, whatever be their vision of the economic institutions suitable for the country, they would try to bring together everyone on one platform. And it also saw equality amongst everybody and said that even people of political parties can be in this organization, and today we stand with that. And it's important because, as we know, during the emergency, the entire opposition, all those who were dissenting, were thrown into the jail, and today also we know who are those who are silenced first. Those who are dissenters and those of the political opposition. So friends, the important thing about this organization is also that Justice started very much from Bombay, from the Bombay High Court, was its first president, and post-emergency, after 1977, this organization was revamped, and what we call the People's Union for Civil Liberties was born in 1980. I just very quickly, in a few more minutes, to tell you why it's important to recall some of our objectives. One of the main objectives of this organization is to uphold and promote by peaceful means civil liberties and a democratic way of life throughout India. This is at the core. Some of the other aims and objects, which is important to in a way look back and see, is to continuously review all the penal laws, criminal procedures, and bring them in harmony with humane and liberal principles. Today, where we are in an era of undeclared emergency, the PUCL has been calling it that for a very long time. We know what kind of laws are continuously made. You just have to laws. In this state, and I come from Rajasthan, we've had similar conversion laws, Disturbed Area Act, Public Safety Act, the UAP, and many more. So we have to work for the withdrawal and repeal of these repressive laws. Our aims and objects say. It also says that at any cost, encourage freedom of thought and defend the right to public dissent. We stand for that. To reform of the judicial system so that you remove delays and other expenses, etc. Prison reform is a very important agenda. Of course, police excesses has been at the core of our work because we know the kind of torture and now the kind of torture doctrine that has emerged that we just saw what happened with the students in Delhi. It's actually something that we have to take on even now and of course finally do all acts necessary that will help to achieve all the above aims and objectives. So friends, welcome once again to this particular evening lecture. At the same time, we would like all of you to also be associated with the PUC. I'm not doing any marketing, but we need everybody today to defend our civil liberties and democratic rights. Thank you so much, and Justice Oka, welcome once again.
I invite the General Secretary, P. Suresh.
Duty to share with friends here our joy of coming back to Bombay for the JP Memorial Lecture almost after 25 years. The 23rd of March 1977 was the day when Indira Gandhi was forced to withdraw emergency and declare elections to take place soon after. Many of us here know that in the very, very dangerous period of 75 to 77 and the year before 1975, 26 June 1975, Jayaprakash Narayan leading the movement of young people, especially all across the country. Sampurna Gandhi movement, we had the students movement, we had the youth movement, all across northern, central part and western India. That is the impetus which forced Indira Gandhi to declare emergency, apart from several other reasons. And he became a unifying force to bring people together to fight the institutional Napoleon administration of that period. Of course, you look at that administration and the emergency of that period and you look at the undeclared emergency of this period, there's a whole world of difference at stake. It is in this context that we need to talk about human rights. And it is in this context that in honor of JP, soon after he died, PUC decided that we will celebrate March 23rd as JP Memorial. Generally, we stick on to March 23rd because that day is very symbolic. It's symbolic of the possibilities of citizens coming together, not necessarily under one political banner or under political, but as a broad-based platform of citizens wanting to bring about change in authority and regimes, bring up accountability and seek justice for the various violations that has taken place. And based on the understanding that it is not just one institution which is responsible for emergency, there are several other institutions which are also equally to be framed or become party to it. We also, from that time onwards, have been focusing our attention, looking at a variety of these institutions that have been taking part in. So that became the basis for a lot of hard work over the last 40, almost this is our 50th year since formation. We will be starting celebration for the 50th year from this year onwards to next year. It is an occasion to remember that behind 23rd March 1977 was the courage of ordinary people to come together to declare that we will not remain quiet. I think that is what exactly is what we did. And through the JP Memorial lectures, we seek both to reignite the emotional context of what JP stood for, and also to have people who will give forward-looking lectures. This will also really give us an occasion to rethink some of the situations that we are in the field of our work. So over the last 45 lectures, all these lectures are available by about 4 or 5 in between. Many of them are available in the website. We also have brought out a book of these things. So I would advise, I would request many of you if you want, please to write back to museum. We will be very happy to share with you. Some of these things are extremely important and valuable documentation of the human rights movement in the last 50 years. We have had a long range of very many people who have given lectures. We've had Nivedita Menon giving a lecture in 2013 in Bombay. We have had Ravi Nair last year. We've had the Dalit poet, very famous poet, Bhava Rangvanshi, and a human some part of the country. So we made it a part of our policy that the lectures are held both north, south, east, west, also in central India. So that every year it goes to different parts. And we follow a certain internal pattern in terms of the choice of topics that we call our speakers to speak on. So in this context, that it's our pleasure, sir, that you readily agreed to come to deliver this lecture. Justice Oka had some other engagement for the 23rd and therefore it got shifted to the 30th. But we are very eager to talk, to listen to him. Because as an outstanding person, his judgments speak for themselves. He doesn't need to speak about the judgments. The judgments are a repository of his vision of how it should be. But even after he left, on the day that he left office, the lectures that he gave, a very self-critical review of the functioning of the judicial system, are something which may have inspired many of us to look into the type of challenges that we are now facing. Because the citizen is finally left to go back to the main place, the only place now to knock, to demand for justice, which is in the judicial system. And the judicial system is on the ups in a way, speaking. And many of what you have said and written, sir, gave us a lot of inspiration and a lot of insights into how these internal things are happening. We're very happy that agreed to speak on reclaiming justice, bringing back the constitution and the people into the judiciary. How do we bring back these things? That's an extremely important part. It reminds us of what Ambedkar said on the 29th of November 1949 when he talked about constitutional morality. In a land, in a soil which does not know what democracy is. So that was the vision of people like Ambedkar. And I should also mention that in the context of what's happening in Iran, of our constitution makers who discussed and debated in the Constitutional Assembly, that the future India would be an India which also talks about world peace as much as it talks about development in India itself. This is the vision which our constitution makers had. And Ambedkar finally said the constitution is only as good as the people who implement the constitution. Ultimately, it comes back to us citizens to implement it. So it is in this context that we are very happy that you have agreed to come to speak to us. We are all looking forward to hearing you speak on this topic. So, we here have conducted a very major exercise of going to Manipur. Support the soft copies and the hard copies. Please stand behind your names and your numbers. And we shall go ahead.
Justice Oka. I can say with considerable confidence that possibly the best year I have appeared before. And it's a pleasure. He joined the bar in 1983. In 2003, he was delivered as a judge of the Bombay High Court. In 2019, he became the Chief Justice of Karnataka High Court. In 21, he became a judge of the Supreme Court, though many of us felt that he should have become much earlier. And finally, on 24th May 2025, he retired. He spends his time, he's taken a conscious decision and he doesn't want to do arbitration. He's not going to do any arbitration at present. He is very keen and he's already doing teaching in various colleges. And that's where his passion lies. Just to give a few examples, and please note these are very few, of the kind of judgments Justice Oka has passed. I remember when he was in Bombay, he passed an order saying that so what if, according to the government or the corporation, certain slots are illegal. Even if they are illegal, you have to provide water, drinking water and eating water. That's one. The beef man that case, despite, I mean, there was already Supreme Court judgment, so within the contours of the judgment, you have to make a way out. And he allowed it. He said that what you want to eat is your problem. You can't stop people from eating what they want. So second, a teacher was suspended because he refused to fold his hands during a prayer. And Justice Oka said nothing doing. If somebody wants to be a non-believer, then it's that person's choice. You can't suspend a person because that person is a non-believer. As far as environment goes, all of us keep on hearing day to day about going to the High Court for taking permission to cut mangoes, which nowadays High Court is very easy. But the requirement to go to High Court for cutting any mangoes is something which was brought in by a judgment of Justice Oka. And he said if you want to cut any mangoes, you come and take a permission. You can't on your own go around cutting mangoes, etc. That is something which he did. He also asked the Supreme Court a judgment by which post facto environmental clearances were held to be illegal. That you first start your project and then you take environmental clearance on it. You can't do that. Of course, unfortunately, that judgment has been subsequently, set aside. The Milghat case which is going on right now here, the malnutrition case, the initiation of that case in Bombay was done by Justice Oka, supervising how right to food, etc. Right to food, malnutrition, medical aid, etc. That was again Justice Oka's initiation. Manual scavenging came down heavily against manual scavenging in Pandharpur, etc. I remember at that time we had appointed lawyers and asked them to visit Pandharpur when the actual yatra takes place, make a report, and on the basis of that report and on various other things, issued a slew of directions. Prison riots, systematic directions here as well as not only in Bombay but elsewhere concerning prison reforms. He came out with a judgment when it was judgment when it was in Supreme Court, saying that even if a marriage is declared to be void, the woman is entitled to permanent alimony. He also came out with a judgment. He delivered a judgment in Supreme Court giving Anganwadi workers gratuity. He also, in number when he was in Supreme Court, there were demolitions in UP, in Uttar Pradesh. He directed 60 lakhs to be paid to the persons whose houses were demolished. He struck down the judgment of the Calcutta High Court, which said basically, which Calcutta High Court judgment says that adolescent girls need to control their sexual urges. That's what Calcutta High Court judgment says. Justice Oka said, sorry, this is not our job. Or, this kind of morality is not the job of judges. Please keep away from this. Freedom of speech and expression and right to protest. When he was in Karnataka High Court as a Chief Justice, he set aside restraints on right to protest imposed by the government. This was during the CA charge in sedition, etc. The network is what is this nonsense? Anybody can criticize if they want to. The article 370 is wrongly advocated. You are entitled to say that you can't be charged, you can't be punished, you can't be prosecuted for this. That's the definition. He obeyed jurisprudence, tremendous. There was a time when the Supreme Court said that in UAPA matters, jail not bail is the rule. And Justice Oka gave a judgment saying that sorry, even in UAPA matters, bail not jail is the rule. It's not that principle doesn't go away. Similarly, when bail conditions were put, saying that you must track the person who has been given bail. The police must continuously track that person and should be available for tracking. Justice Oka struck down that condition, saying that sorry, this is violation of right to privacy of a person who has been given bail. You can't do all this constant tracking of that person. That's not something you should understand. Similarly, under UAPA, he interpreted section 38, section 40 of UAPA in favor of those who have been wrongly accused of those crimes. I can go on and on, but I don't want to because they are not come here to hear about him, but to hear him. So I will stop here, but I can only say that he is one person, both in respect of civil as well as criminal, both in respect of civil political rights as also in respect of socio-economic rights. In respect of all that, a slew of judgments which have been passed by him, right from the time he was in Bombay High Court, Karnataka High Court, I remember Bangalore lawyers pulling me up, saying that, wow, who are you sending to us? I said, yeah, I'm sorry, I will send it to you. You should have been here. So that was I'll stop here and I'll let Justice Oka now take over.
Nice meeting. Dignitaries of the dais, dignitaries of the dais, members of the bar, and friends. The subject you are so interesting, reclaiming justice, bringing back the constitution and the people into the future. When I was contacted for this lecture, I decided to say yes immediately because of the subject, and second reason was it was in the memory of late Jayaprakash Narayan. When Sampurna Kranti movement started, he started at least 73 or 74. I was like 30 years old. Fortunately, I was born in a family where my parents had made it compulsory to read one Marathi newspaper and one English newspaper. So I was reading without understanding the movement which Jayaprakash Narayan did, and he became a youth leader of the youth. And then, of course, in 1977, he kept on reading about his ill health. This lecture gave me the opportunity to revisit Jayaprakash Narayan. And I realized that people of my generation, whatever is written, we knew him as somebody who led agitation against the Indira Gandhi government. But I have not studied the other parts of the great work done by him. He was fully a Gandhian. He was a colleague of Vinoba Bhave. And I found from his writings, his speeches, that he was a strong supporter of non-violence. Normally,
that who accepted non-violence and have declared themselves to resist whatever evil that might come with non-violence. So there is much to be said about Jayaprakash Narayan. When I was reading about him, I felt that I think he should have continued in active life for at least 10 years. Because perhaps what he started in 1973-74 in Bihar was incomplete, firstly because the emergency was needed, and secondly because he had to quickly figure it out. So perhaps active life for 10 more years will have seen perhaps a different India that did not happen. Now let us come to the topic today. In one sentence, the topic is where do we see judiciary today? And this has to be in the context of Constitution of India, because after 26th of January 1950, all courts started functioning under the Constitution. And as we know, Constitution guaranteed justice, social, economic, and political. And I believe that the guarantee given by the Constitution to our citizens of justice, social, economic, and political, that guarantee can never be fulfilled unless our courts are able to deliver quality and expeditious justice. Today, of course, I am going to express my personal views, as my judgments could be wrong, these views may be wrong. But one thing which I have consistently said by our judge of the Bombay High Court was Chief Justice Oka, that to an extent, judiciary is facing crisis of credibility. And I have repeatedly said this, that when the courts in India started functioning under the Constitution, the common man, the citizens of India had great expectations from this legal system. And somehow all those expectations could not be fulfilled by our judiciary. And of course, we have similar, I said so on public platform when I was a judge, that somehow after the Constitution came into force, those who are associated with judiciary, the judges, the lawyers, somehow they kept on saying, or they kept on patting their own back by saying that judiciary is the last resort for common man, etc., etc. I never believed that, because I always felt that if somebody is to say that common man has great faith in the institution, it should be said by persons who are outside the system of judiciary, not the lawyers or the judges. And of course, I have criticized the judiciary. I have said what good things are done by the judiciary. And I must say that when I criticize where the judiciary has gone wrong, I was a member of the judiciary in 3 different courts, say for 21 years and approximately 10 months, long time. So of course, when I say that we were not able to fulfill expectations of common man, I must also take responsibility, because I can't run away from that. As individual, I was part of that institution, and I can't stay and claim that I did something different. That's not proper for me. I was part of that institution, so whatever is the blame, if people want to blame the institution, I must share that. Few things which I want to say in the beginning. To an extent, I am eternal optimist, and therefore I want to begin by referring to certain aspects on which judiciary has done well, may not be in the immediate past or may not be today, but in the past. Instance number 1, prison justice, which was all started by Justice Oka. There was a justice contemplated in the preamble, but thanks to Justice Oka, the word concept of social justice, which is different from justice, social, economic, and political. Labor jurisprudence, the triple test in manual water supply, judgment of the bench by of the Justice test. Of course, now it is referred to larger bench for witness to see what happens for the larger bench. But as a student of law, I was read and read that judgment. And very interesting thing which I read some long time back was I think 1980 to 83. The government brought about amendment, Government of India, Central Legislature, which provided for definition of industry for considerably giving narrow scope to definition of industry, but that amendment was not brought into force. And one thing I always say is about Kesavananda Bharati. Surprisingly, the origin of that concept we borrowed from the British in Pakistan. This is probably a case which was followed by Justice Oka in minority insurgencies case. I personally believe that this is one case, Kesavananda Bharati, because of which India stands on different footing than our neighbors on left and right side. On the very extent it saved us, it tried to save the constitution and then environmental matters. Of course, many of you will say that what Supreme Court has done in environmental matters, maybe now there is a change of or shift of approach. Maybe now we are moving in backward direction. That or what? Please imagine what would have happened if there are no Buddha, if there are no data. Please imagine what would have happened if there were no Vishaka. The legislature took almost 30 or 14 years to come out with the enactment and in that time Vishaka operated. Same is the true with the judgment of the Supreme Court holding that right to education is part of Article 21 and then for a long time thereafter Article 21 comes. Talking about Maharashtra, we had a very progressive legislation, at least I believe it was progressive legislation, that was Bombay Against Agricultural Lands Act 1948, which conferred status of owners on the dealers who were actually tilling the land on the dealer's day. Bombay Act 1947. On these two enactments, there are beautiful judgments written upholding the rights of the tenants by Bombay. There is one area on which I always discuss with the students. And why I started discussing with students this area because in one law school, I was sitting judge, one student brought up, he said, why such a long trial was given to Ajmal Kasab? Somebody complained about the bomb blast trial 1991-92. It took 12 years. So I always told the students that I have myself said that I have myself being a critic of the system, but please consider one thing. Our system gave a very fair trial to even Ajmal Kasab for his Article 21. I don't think any other country, neighboring country, would have done that. Mr. Gandhian, we know that a very seasoned lawyer was appointed for him confirmation case in Supreme Court also the same. Lot of critics criticized that 1991 Bombay Blast judgment took 12 years. We see the record of the case. During the tendency of trial, police went on the investigative went on arresting accused. Accused were arrested. Every time the judge had to set the block back, he recorded all prosecution witnesses so that the new arrested accused can really cross-examine those witnesses. The enormity of the trial, only one instance I will tell you. The statements of the accused recorded under section 313 of CRPC ran into more than 6,000 pages. Now, what are those statements? The court has to record what exactly is the evidence against each individual accused. So, preparation of these statements must have taken months. And all of us know that when it was under Tara's appeal was written to the Supreme Court, it required full railway wagon to carry the record. So, one aspect we must also remember, see what actually transpires in our criminal court, what happens in trial court. Of course, it's a matter of great precision. But procedurally, we have a system in place which can give a fair trial there are judgments, very recent judgments Supreme Court, that even the statement of the accused under 330 is not properly recorded, entire evidence is not put to him. That may be ground of acquittal, because after long hearing, case can't go back. And one more thing which I want to say about high courts. Please study the orders passed by the high courts in COVID days. I am not talking about Supreme Court. Kind of orders which were passed, where there was protection to transgenders, protection to young students who are getting midday meal. So please imagine if these orders were not passed in COVID days by all those high courts what would happen. And now I come to the topic where we have gone wrong. About that also there are different perspectives. But somehow I feel I am going to talk about liberty issues and the Article 21, environmental issues, but later. So where we have gone wrong? I think when we discuss this, one fundamental mistake which all of us committed. There are very elderly people sitting here. You must have read news reports about various conferences, complaints made by the lawyers. So whenever there was a discussion about legal system, we discussed with the Supreme Court and High Court. Unfortunately, very rarely we discussed our trial and district courts. And I think when discussion used to take place about where and why, where judiciary is going wrong, or what are the system, we talk superficially. Somebody always talked about long vacations taken by the judges. Somebody talked about judges not declaring their assets. Somebody talked about micromanaging the High Court. Now, unfortunately, that why judges are taking more than 3 months to pronounce judgments without realizing that. Judges, they compare, they will give 150 cases every day. And there are cases where record runs into just of cases. You are not expected to deliver judgments in 3 months. Now, micromanagement to some extent that after you pass order to take in a particular time, you must upload those orders. My view was slightly different. In fact, I was criticized by the members of the bar that my orders never used to be available immediately on the website. But my policy was that I will take the risk of delaying the orders, but I will try to learn more and more matters. Because it's a matter of time that you get the orders. So, all superficial discussion, there is going on and all sorts of things. But the first thing which we overlook, which I have again said repeatedly even as a judge, that failure of our system to be important to our trial courts. Please look at the powers of the civil judge from judicial magistrate first class. If we had revamped these courts, what are the powers? Please imagine. Now there are a series of judgments that under Article 22, as soon as a person is arrested, he must be punished with grounds of arrest. And now I think Gandhian was one step right, says that that is judgment is prospective, that this is Augustine must be judgment, that 2 hours before he is produced before the magistrate for the first time, 45 must get ground for arrest. Now the judicial magistrate who deals with remand has power to say that the arrest is illegal because there is non-compliance with Article 22. Your act is not produced before in the span of 24 hours, so there are mass powers. And somebody must study, in fact, some kind of study undertaken by some institution in 2007, 2008, which indicated that if we have a clear system, the civil judges, magistrates, and then session judges, district judges, appeals, because that large number of litigants, be for social reasons, or whatever reasons, those who do not succeed in these courts, they don't go to the land court. Somebody must make a very detailed study. And what we perhaps made a mistake was always branding these courts as lower courts, subordinate courts. Without realizing one thing, I remember when I attended a workshop, and the point which I am telling you I did not get, that was way back in 2007. Well, some speakers continue to refer to the High Court and Supreme Court as constitutional courts. Then I suddenly realized one day, read Article 230 onwards, they deal with appointment of district judges, conditions of service of civil judges. So, in a sense, after Constitution, you can't say that only High Court and Supreme Court are constitutional courts, but all these courts at grassroots level, they are also the constitutional courts because they work under the Constitution, their foundation. So we kept on writing in lower courts, lawyers appearing in lower courts, as if lawyers appearing in the higher court, like High Court is superior to lawyers appearing in higher courts. So, because please remember, we did not have time to go deep into it. Only the factors are available. Some widow is fighting for a share, undivided share in half acre of agricultural land. Some small disputes were only property disputes, partition disputes, matrimonial disputes. I am going to deal with matrimonial disputes. Somebody fighting for maintenance. These are all matters, common man matters. The trials, the bail applications, all covered by these courts. And I'll come to that, how we have neglected these courts. Another important issue, which again has some basis, because we always talk about what we call it as huge ideas, docket disclosure. When we sit in the court and we discuss, how that 498 of IBC is being misused by women. We sometimes say how that SC and SCI is being misused, because certainly those cases come before the court. But having worked as chairperson of the Legal Services Authority, I have gone to legal aid camps and seen the situation at grassroots level. Fortunately, as a lawyer, I had opportunity to work with some NGOs to do some medical relief work in rural areas. So, the problem there is that still there are a large number of citizens, a large number of women who suffer injustice, who suffer violence, but the social and many other reasons they don't complain. So when we talk about delays and docket exclusion, we must also remember docket exclusion because that is where our society has not made progress. There are people who suffer silently and injustice related to them. It's a fact. And we have legal aid machinery. We have legal aid machinery under the Legal Services Authority Act. But there are limitations to that machinery because there is not enough manpower. We don't have that kind of legal aid machinery to move from place to place in villages and we find out whether there are any offences committed so that FIRs can be registered. Our legal aid machinery remains confined to somebody appearing as a remand lawyer and accused goes for remand, or somebody going to jail, advise drafting copies and bail applications, etc. Of course, one effort was made to fight Bombay, but Mr. B. this time may be aware. There was a case for some nuclear power plant to villages in space, and their Legal Services Authority was appointed to oversee the rehabilitation, and rehabilitation could not happen properly. Their Legal Services Authority played some role. Primarily also some states role was played. So, when we discuss what is wrong with our legal system, we have to also consider the grassroots level situation. In this I talked about that POSO case which we decided. But that POSO case for me was an eye-opener about how our society functions. I'm getting into divergence is the base this topic and this happens in many cases. So 13 or 14 years old girl, she became pregnant. And the problem in that case is that her parents deserted her, the society deserted her, there was nobody to support her, and therefore she had no option, no choice but to go and stay with the accused. These three two judgments, operating. So she was without any support. So the principle which I heard is there was no opportunity to that young girl who suffered such a horrible offense to make informed choice about how she is going to lead her future life. Of course, things are better, she is taking education, the government has provided a better facility, and that's the different thing. But when we consider failure of legal systems somewhere, we have to also consider the one society where we are lacking. But ultimately, it's not only justice rendered through court, it's about access to justice also. It's about how the society treats the victims of the offense. Now let us come to the trial course. I am generally talking about pan-India picture. Please visit, most of you are visiting magistrates court in Mumbai. 100 cases, 150 cases every day. I expected in criminal procedure court to bring in some reform, but if you go to that court, you will find about 100, 150 cases are there. I think 30-40% are under 138 of the Negotiable Instruments Act, check bouncing cases, many cases under the Domestic Violence Act, maintenance cases under Section 125, and criminal matters. Huge amount of time is wasted on the judges in recording attendance of the accused, because accused are on bail, they have permission to attend the court every day. I always felt as a from the order that now we must actually do something that we should grant exemption from appearance unless cases for effective hearing. So much of time is wasted on the magistrates on that. And you see, just imagine these young judges who sit here. Day after day, we 100 cases, 150 cases. And very few people know these young judges, they get 6 holidays, second and fourth Saturdays and 4 Sundays. Out of those 6 holidays, at least 3 days spent in attending legal aid workshops, workshops conducted by guardian judges, local adults, etc. They are all young judges having young family. And this is the kind of pressure of work, there is a pressure of work. And so what happens is, day after day, if you read 100 cases, 150 cases, you develop a mechanical approach. And then there is hardly scope for innovations. Now, why this is happening? This is happening because we have only inadequate judge population ratio. I have said this from the top of my voice, I said it in my judgments, I said it in the constitutional judgment, that in 2002 Supreme Court passed an order directing that the final judge population ratio in India should be 50. So in 2002, today we are struggling at 22 or 23. Then how do you expect these grassroots levels? These are common matters. So I have repeatedly keep on saying, how do you expect these schools to perform? And then we always talk about Viksit Bharat, we give examples of so many developed countries and say what kind of robust legal network they have. When we ignore that some countries, their names are taken, they have just the population ratio of 100, 130, 90, 80, and all those figures we find in 2002 reported data on the Supreme Court. Today we are struggling at 22 and 23. In the meanwhile, please imagine what has happened. Large number of new cases have come up. Cases under the Negotiable Instruments Act, Domestic Violence Act, matrimonial litigations. I talk about it. This is one category of litigation which is going to affect or already affecting our judiciary. So, this is the first thing has to be done. There was order passed by Justice Chandra that he appointed Professor Mohan Gopal to work out a formula how many should be the ideal number of judges in every state. So there were direction of Supreme Court in 2016 that adopt that formula and make a calculation of just 10 required in trial and district courts and submit a proposal to the government. I was chairperson of the committee. If I am not wrong, even if we consider to estimate into the approach of the government. So he said we require some 8,000 and more judges for the trial court in Maharashtra, and I am told only some 800 posts have been sanctioned. Now, who is going to ask these questions? And nobody is asking these questions. How do you expect a system to perform when minimum number of judges are not there? It's not about judges. Please go to some of the posts in Maharashtra. Pune, for example, there are senior civil judges posts, 2 or 3 posts. They have unlimited jurisdiction, like judges on the original side. Now they have small rooms before 4 hours and after 4 hours. The rooms become their chambers, and during 4 hours, they are in courthouse. There is no place for litigants to sit. What kind of classic example? And diverting the name. This is only one network in the entire country where the litigant wants to come by to either a moped or a bicycle. He has no place to park that vehicle inside the compound. He has to park in far away place. They are always talking about from the litigant's point of view. So, therefore, how do we achieve the progress in our legal system? Please understand one thing. Those court or magistrates court. They can't be forced to spend more, engage costly lawyers in High Court and Supreme Court and fight for the bail. So this is one area, and please remember one thing: we need good infrastructure. We need good infrastructure. It's not like you appoint judges in duty; it has happened. In duty, because of a demand, the government passed an order creating more courts. But no judges could be appointed because there are no courts. There is no infrastructure. So this is one area where we have to really struggle hard to get judges appointed. Those who are practicing Bombay, they remember Justice Oka created a special bench of infrastructure, support infrastructure matters, where we have to lay down a law that right to have infrastructure, and it's a government's obligation to provide infrastructure to the court. I always give example of Sangli District Court. The court was in shambles, so there was a proposal to construct two towers, one administrative tower, one judicial wing. Government rejected the proposal for administrative wing, or sanctioned proposal for judicial wing. And we have to issue a letter of mandamus, and the supervision of court about 10 to 15 court complexes were constructed. So this is actually one area that we are lagging far behind. And somebody must make a study. How many litigants afford to carry their matters to High Court and so on. The second area where I feel, and again I may be wrong, that we know that we have huge dependency. I'll come to that. Why people have to approach the court? I'll come to that. Especially Great Court. I've seen those kinds of litigation where the issues we need to resolve at the level of some section officer of the government, people have been engaged lawyers with 5 years of mandamus. I think we are not able to properly fix our priorities. And what is the meaning of priorities? Which cases should be given priority? One notification was issued by Supreme Court that please give priority to litigations of all senior citizens. According to me, I said so in my orders of this. Completely wrong. Now in Bombay High Court, they have said at least the third generation of litigants are the parties. Now should we give priority to a case, any case where 60 years old man is there or woman is there? Or should we give priority to those cases where third generation of litigants is possible to get case? Same thing applies to family court matters. Sometimes before me, lawyers used to apply, sir, in family court of my client is more than 60 years old. I should tell them, look, there are cases of somebody who is in 30s and 40s. They must be given priority. Now, under trials cases, no doubt they should be given priority. But two areas that I have commented upon. One is because we don't know what kind of litigation we have. We have common man's litigation. We have litigation of laborers, we have litigation of workers, teachers, and whatnot. Was it necessary to have a commercial court act in Indian situation and to say that give priority to the commercial court act litigation? And there is some procedure there that under section 12A, you have to go for compulsory conciliation, mediation or conciliation. And then, you know, that kind of petition is filed. Rejection of claim, etc. So, was it necessary in Indian situation to give priority to commercial matter? Because talking in Indian context, see, when I am part of the judiciary, I am not concerned with India's ranking in World Bank or some international organization. I am concerned with dealing with litigations of deserving litigants. So, I always wonder, we talk about commercial litigation. Unfortunately, I may also use that phrase. But maybe I have heard it this way. How commerce can be associated with litigation? There is a question of commercial litigation. And as a part of that, one criteria of social instruments, purely a civil wrong. Purely a civil wrong that we have converted into a criminal law. And please, someday, somebody must study those complaints filed in the Commercial Instruments Act. There are so many complaints which I came across which are actually made for recovery of unaccounted money. Because the moment check is disordered and aggregate position check is issued by the account holder, there are presumptions. So was it a the 138. And what take the backseat are dispute arising on matrimonial matters, offences, magistrate trial offences. There are also some of the offences are very serious offences, where there are victims of the offences. Maybe in some cases, when a person is on jail, only because the cases remain pending, they face so many restrictions. So that's area only some debate is required whether in Indian condition we should give priority to commercial matters. Secondly, under the Arbitration Act, there are provisions that priority should be given to section 34 petitions or section 37 petitions, 37 appeals. Now, mostly these arbitration disputes, firstly they are in the connection with government contracts, and otherwise they are all arising out of commercial contracts. Disputes between two entertainers who are otherwise well off. So, can our system afford to give priority to arbitration matters? Of course, that's not the reason I am not in arbitration. I did after occupying highest office. I should not be applicated work. And in the advocate, I will say that 22 years of justice, I was tired of hearing noise, so no more hearing of noise. But still, how much importance can be given to section 34 and section 9 petitions? Now, these are the issues which we require application of mind. And these are the issues which are very, very relevant to the problem which you are facing. And courts are not able to perform their duty. They are not able to fulfill the expectations of common man. So, I always give a classic example. I'll come to that later. One issue which I want to highlight. As said so in the Constitution bench. As a lawyer, as a judge, I have seen one very deep that people sitting in the High Court, telling the trial court, decide this case within 2 months, decide that case within 6 months. People sitting in the Supreme Court telling the High Court, you are going to decide the matter on the same day. So what happens is, see there is a hospital in suburbs, and it had very industrial family, and for I don't know for how long, 25 years, disputes are going on, Civil Court, Magistrates Court, Charity Commissioner's Office. So as a judge, I always found that that dispute was to go to Supreme Court, case was to come out in a time bound schedule, decided within 3 months, decided within 6 months. I said so in the judgment, therefore I am saying it. See, this kind of a thing sends, one thing sends wrong signal that somebody can afford to go to higher court. He comes back to the order so that his case gets priority. That is one part of the academic part of it. So, boys are practicing sessions court. Every session judge is doing criminal matters in state court judge. You will find that he has 30, 25, 40 time-bound cases. What I feel is that when we sit in the higher court, we don't know the grassroots level situation in a particular court in which case is mentioned. I feel that what is all this? This appeal, this criminal appeal in the sessions court is of 2010. So decide within 6 months, but I don't know that in that court there are 2005 appeals pending. So I gave 1.5 sitting in the higher court. Therefore, in Constitutional Bench judgment, we have said that no higher court can do that. Because as far as priorities are concerned, they have to be left to the concerned judges. They only know what is the kind of pendency in those courts. Because, and again, I said, it sends wrong signals that if you can afford to go for higher court, you come out with a favorable order to get out of term priority to your case. And there, the question again arises of priorities. So, is it correct for higher court to say that because one case goes to them, should be decided on priority basis? It happens in bail applications. Sometimes we judges feel that no, it's not a case for bail, but I satisfy the lawyer by saying that decide the case within 6 months. And I don't know whether the charge is framed, because on the charge is framed, trial can't start. But I give the psychological satisfaction to the lawyer without realizing that in that particular sessions court, there may be 10, 15 years old older trials. So this is where they are going wrong. Now, why cases pile up? Why there are more and more cases? I want to tell you. I sat extensively Aurangabad bench in 2012 for read matters. what type of cases people have to come to the court, please understand this. And these cases actually deserve priority. I don't know what is the position. I read because I violated the judge also. You know, we have teachers who work in grade schools, primary teachers, secondary teachers. And what happens is, especially in case of women teachers, they go on migrating from one place to another, so leave one job, go to other grade school. And there are gaps in the service, breaks in the service. So, there was some kind of government resolution that 3 breaks can be controlled by, I think, officer of the deputy director level. And 3 more breaks are there, they can be controlled by director. Unless teachers come to read court, nobody should get that leave. So many cases people have approached the court for pension. In so many, you can find so many cases where people go to the court for retirement. They are all small people. Now, unless they go to the court, you don't get relief. In Karnataka, I saw a unique phenomenon. So, a small person, he saves something from his service or his occupation, goes and buys a small piece of land. Now, there is a landowner act there, not a court landowner act there, which mandates that the moment there is a registered security, they must be entered in the regular record because person uses his life savings, purchases a land, he gets that kind of satisfaction. I acquired property in the age of 60, 65. But he has to go to read court to get his name added in the regular record. So if you don't have your name in the regular record, you can't enjoy the property. So many cases where people are forced to go to the court because they don't get justice at the hands of the executive. Now, this is one reason I talked about girls, victims of not getting support from the society. But these are cases we can avoid it in Supreme Court. I found, those members of the armed forces who suffer disability in service, they are entitled to disability pension, so they go to armed forces as well. They get pension, but in the order comes to the Supreme Court. So I used to ask additional solicitor general, what is wrong? These people work in army, and for technical reason, they get some disability pension, but coming to the Supreme Court, they are being very loyal. Other classic case which I remember in Supreme Court, that reservation for persons with disabilities. Reservation was not imposed. In fact, some of the matters I remember, people had appeared for civil service exams, so we had to exercise power under 142, and we said, whichever is their service, give them employment. Don't give them back wages. And these matters would have been sorted out there, after all, people with disabilities. So, one reason why our system is crumbling under pressure is these kind of litigations. One more classic example, I think Mr. Veer decided for. I wrote an article in one of the leading Marathi newspapers and said that we are talking because of wrong concept of development. Building metros and bridges and roads is not development, they are all infrastructure roads. And Bombay, come to Bombay, and the bigger city for the country. Take a case of somebody who is employed, say, in small district in Maharashtra, getting salary of some 40, 45 rupees, is transferred to Mumbai. He cannot afford to have legal accommodation in Mumbai. He cannot afford to have. He has to go to some illegal constructed slum, stay there, pay very high rent. This is because there is no concept of affordable housing in our cities. And the moment you start constructing illegal structures, there are a number of litigations. People have, Mr. Desai referred to a case where the issue was whether people staying in unauthorized slums are entitled to water as a matter of right. We said, article 21 right to shelter, right to water, so long as they are staying there. So, these kinds of social situations create litigation. Please find out from the courts in Bombay how many cases come to the court because of these slum areas. And unless we have affordable housing, we won't be able to stop this. Where people will live. Same case which Mr. Veer decided, but there was statistics based on record that 27% of the police constables stay in unauthorized places in Mumbai. So there is no housing for police. It's a matter of record, official record was produced. And one more area where our system is coming is matrimonial disputes. Matrimonial disputes are on the rise. Now, one matrimonial dispute creates 5 grassroots litigations. Maybe 125 CR, this will be new marriage act or special marriage act, Domestic Violence Act. Unfortunately, there is child and custody issues. So now, medical litigations are raised during medical litigation has potential to create 5 different grassroots level litigations. In those applications, revision applications, special petitions, appeals, and whatnot of the Supreme Court. Now, we don't have robust machinery in our society where before people go to the court, there can be some kind of a either reconciliation or golden handshake, parties separate by arriving at certain terms. Please look at the situation of family courts. There was such a fantastic idea about family courts. Some of you must have attended the groundbreaking ceremony of new airport complex in 24. I was there the first groundbreaking ceremony, but there was one more ceremony in last year. So the first groundbreaking ceremony, there was Chief Minister, Deputy Chief Minister. So I said, sir, it's a good idea for my judgment that you land to the airport complex. So I have to say that it's a good step taken by the government. And still, your 50% land is not given by the government. That's not a subject today. I said that when we are celebrating this event today, at a very short distance in Bandra, where the first family court in Maharashtra was established, additional building of the family court is under construction for 8 years. There are only 7 judges in the family court right from 2005. But I don't know. I am not sure that the construction is completed today. Now in Bombay, family court work with 7 judges and litigation has multiplied in the last 20 years. There are many lawyers who appear in these matters, so they may be aware. Again, this is a classic case of neglect of grassroots level courts. Now that is where I think now we have to set our priorities right. Then I talked about environmental matters, the landmark judgments of the Supreme Court, etc. When it comes to duties of the court, one category of cases is Article 21 violations, liberty matters, which involve not only denial of bail but also cases where people are being penalized or prosecuted based on speech violation of Article 91. They are all liberty matters. And I always say that environmental matters are liberty matters because right to have pollution-free atmosphere is a right guaranteed in Article 21. Associated with MC Mehta last 2 years and the case in the October, etc. One lawyer got up and he said, sir, this is all like this business. You are talking about pollution in Delhi 400 years. I said, no. Like these people, they can afford to have those machines in their house, air purifiers. But in Delhi, majority of population, it works on the streets. Somebody works at the somebody has some food stall, somebody works at the other Isha driver. I said, these are the people who suffer because of pollution. And in fact, there are statistics available in the public hospitals who are suffering from lung diseases, not people who stay in comfortable houses, but people who are on the street. So these are also Article 21 pollution issues. I met certain activists last year in one of the conferences in Delhi. They said, sir, you are talking about Delhi because Bombay is not far behind. So far, Bombay is saving because of speeds, speeds, but we don't know what will happen after a few years. So, they are liberty matters. If you cut 45,000 mangroves, they become liberty matters because we don't know how devastating it will be the effect which will be felt maybe after 6 years or 10 years. Now, problem with liberty matters, like bail, is that in deserving cases, when magistrate tribunal cases, people don't get bail. I am not here to justify what is happening in the tribunals. But please remember what kind of attack judges face to grant bail on the social media. On the social media, there are so many complaints filed to the High Court. See, when I became a judge, people should discreetly file complaints against us by sending it to the Chief Justice of India, Chief Justice of Bombay. Now, if any complaint is filed against our trial court judges, first copy is delivered in the chamber of the judge or at the residence of the judge. So, all sorts of allegations which are made against judges must be read by his family members also. 90% of complaints are frivolous, 10% may be illegal. So, whatever reason, that reason we have to combat. That why deserving cases where people don't get bail in the trial courts, why deserving cases where, say, case for acquittal, people are not granted acquittal. What are the reasons we must find out? Because this also leads to a situation where our legal systems fail because ultimately they grant you what you have been released on bail, say by a magistrate in magistrate trial case, he has to travel up to Supreme Court. You are adding to the pendency, artificial pendency. And quite honestly, somebody says now that in the sister approach, there are so many judgments about violation of Article 22(1), where you have to publish grounds of arrest. But while the approach of the courts is inconsistent. Same is the case with the law laid down in Najib's case, Article 21. Actually, that law is so simple that in those cases where there are no prospects of trial commencing, huge number of witnesses, and person in jail, non-incarceration. Non-incarceration term which we have to necessarily consider in the context of maximum sentence. So, the basic concept in Article 21 is that pre-trial or pre-trial incarceration can't be converted into punishment, and therefore the judgment series of judgments. Now, question is how many high courts are following your judgments? And of course, you can criticize that some measures Supreme Court are not following. In one case, it happened daily. So, and please remember that this jurisprudence is still evolving. 5 years back, there were no major judgments on the issue of grounds of arrest. Now there are judgments in the last 5 years. And therefore, sometimes I always say to young law students that don't think so negatively, at least there are progressive judgments on grounds of arrest in the last 5 years. They are not there earlier. But these are the judgments of the Supreme Court. The question is how many high courts follow, how many high courts follow those judgments. Same is the case with freedom speech violations. Those Supreme Court judgment even refers to stand-up comedians. Question is why the stand-up comedian could not get complete relief from the Bombay Act. So these are the issues. And environmental matters. Whether are we taking some other path inconsistent with what happened in Vinoba Bhave and incident, and so many judgments. That's the issue. Same is the case with demolition cases. When there are actions of demolition taken, I remember a case in pandemic and lockdown was going on. Certain huts were demolished. Nobody knew who demolished it. So we have to take very strict action against them. So these are the cases who gets flooded. And all these cases raise very important issue of Article 21. If people construct legal structures stay there, maybe for 40 years, 50 years, of course the structures are illegal. I am saying this in the one case from Aladwani, the work structures there, for 50 years structures are there. Now the issue before the Supreme Court is whether they should be rehabilitated as a matter of right or it should be just by the mercy. Now if you speak, I am not talking about commercial premises. I don't think we should. Taste is different. People stay for 50 years. Of course, they stay on lands which are earmarked for railways or some public project. But in these cases, why should people approach the court? Why can't state apply Article 21, right to shelter, and say that all right, you are not illegally constructed structures, but we rehabilitate it. They are in a decent manner. Not like Mowling doing that, they are rehabilitated in the area where there was maximum pollution. But why state can't take that stand? And of course, why courts can't take that stand? That is the question many of you will ask. That if state is not taking stand, what prevents the courts from taking that stand? So, these are the cases which are coming in large numbers and we are not able to deal with those kind of cases. look at what happens in daily life. 100 cases and then 50 cases every day. So already I talked about listing, lack of transparency in the roster of the Supreme Court, etc. That's a different part. And again, these are matters where we need to work. There is no fixed roster in Supreme Court. Some subjects commonly assigned to many benches, so some at some level somebody decide which case to go, which court. It's not like I court that today I file a bail application. I know that it will go for court mark on the so and so. That's not there. So even in those areas there are huge challenges. Because when we talk about listing, it has direct connection with transparency in judiciary. Whether there is transparency in listing. So there are questions and questions. I don't know how many of you have read books written by Vinoba Bhave by Dr. Gandhian, great author. And these books actually, what he says is eye-opener. What happens in the society? He has talked about drug addicts. He has written a beautiful book on Punia in Bihar. What kind of situation was there in Punia when he went there with some social workers. The point is, he has written a beautiful book. The title of that book is Prashna Prashna. So questions and questions. So this is what happens in case of our judicial system. And therefore, actually, when we analyze the whole scenario, so many unanswered questions are there, so many areas, especially trial procedure that we part. And last thing, which I think I already said about listing policy, priorities, which cases should be given priority, etc. Another important issue is about appointments in the High Court. In last April, the entire collegiate system is on the website. That how the High Court collegiate service is being, what is the format, the Chief Minister gets his say, what is the format of highway reports, what is the format of views expressed by the government of India, how they are placed before the collegiate. One major parliament system is after Supreme Court Parliament recommends the name, good candidates have to wait for 1 year, 1.5 years. And I have always said that transparency has to be in parliament system. And publishing resolutions to go make about transparency. Sometimes you compromise the privacy of that candidate. What happens? Not in Bombay, but at other places, I see in Calcutta, once the name appears in the parliament resolution, workflow completely stops. And a candidate is taken for 45 or 50. He needs money, he has a growing family, and 9 months, 10 months, he has to simply wait. We talk about transparency. Now, Supreme Court has become transparent, they have explained what is the procedure in college. But nobody knows what is the procedure followed after Supreme Court college recommends. Who takes the decision? Why matters are kept pending? One classic case from Karnataka, I say, and I stop. I persuaded a young lawyer, a very brilliant lawyer, just about 45 years old. He was the judge, and everybody in the bar, like I said, he said, oh, this man is doing about transportation. So his name was recommended, approved by Supreme Court, related by Supreme Court College. Ultimately, he waits for 1.5 years and says, sorry, I will withdraw my consent. And the gentleman used to appear before me every day, of course, with businesses in the Supreme Court. So I will always used to regret that this man should not be standing in front of judges, but he should have been standing somewhere else. But this also is a very important area because these leaders, just Vinoba Bhave said it differently in Bangalore, that why competent lawyers are not willing to give consent to become High Court judges. So this is also one area because when we want quality justice, we want quality judges also. And if we don't have a system which will give us quality judges, that will reflect on the performance of the judiciary. So I will close by saying, of course I will begin by saying that there are certain areas that judiciary has done well, and you can't deny that. Even today, we get some judgments which give us a hope. I remember the judgment, after not the judgment, I think next day, the judgment by other appointed bench in no uncertain terms. It reaffirmed Najib, it reaffirmed all successive judgments and Najib in Article 21. So there is a hope, not that all judges are bad, not that all judges are not performing. Some of the orders you see, orders of discharge or any orders passed by trial courts or sessions courts, They are very encouraging. But what I am giving you is a picture where we come to the conclusion that the judiciary is not able to fulfill expectations of common man from the judiciary under the Constitution of India. So this is just overview. And idea of saying this, that again I say that I may be completely wrong in what I say. Idea of this discussion is that we must try to find out what are the real issues, not those issues like lesser application and all other things. Without knowing that we take names of some countries, there are no tendency. But find out how many days the Constitution could there is no. That's a different topic, I am not on that. But we must find out real reasons. The emphasis is on finding real reasons. And ultimately, this is one forum, UCL, which has done so much for the cause of justice. Now, this debate has to be started that where exactly we need improvements in the judiciary and what exactly we need to do to make our trial judiciary very robust, effective, and very bold. I thank all of you for giving me this opportunity. Idea is to set a thought process in motion, and I hope that this will be carried forward by all those great activists who are sitting here. Thank you.
Thank you, Justice Oka, for a very, very transparent lecture. Talked about problems in the judiciary and also some of the positives. We have very little time, we can take about 3 or 4 questions.
Thank you, sir, for raising your presence. So, I particularly want to talk about environmental matters and regarding the 45,000 macros judgment. And basically, I mean, everybody here and you know about what is happening in a scenario where the judgment talks about having judicial restraint, leaving technical and policy determination to the domain of competent authorities, and where the court has not done any assessment, where it has sort of laid down a condition that if the execution has taken a well-informed decision or not, then the court has no need to interfere. My question is that in these sort of big scale infrastructure projects, which are termed as projects of public importance, what is the basis of courts to decide whether there is a need to interfere or not, and whether the courts should have employed any technical authorities, because then how can the court even make a decision on
See,
giving an approval?
I will answer this question very quickly. One, mangoes form part of the forest. No doubt about that, because Dr. Bhave was learning us these things at the lead directive. Master Pudam did this. Yeah, of course, it's not adopted in Karnataka, even in MC Mehta case, and it's no side. That there is a public project. What needs to be done is somebody this kind of exercise is not done. If this exercise would have been done, from my experience, I tell you, in Bangalore, practically every case that we send there, issue to the committee, we could save 25-30% of the fees. Right? So that approach needed to be adopted. I think this year. Of course, there are larger issues that other issues are also there to go on. Of course, they took permission under section 2. I don't know. It was permission under section 2. Another question is one sentence in the judgment of the Bhave that members should not be discontinued, but in extraordinary cases they can come to the court for permission. What is the scope of that sentence? So, to cut the part short, this exercise should have been done, and I am sure this exercise would have been done. Large number of members would have been saved. And another issue where there is can there be plantation of members? Can members survive? They are not. I am not a botanist. That is possible. If you artificially plant members will go. I don't think so. So that issue also needed justice. Maybe, as I said, I am another optimist. Maybe after 2 years that we change our view, we will be able to say members was modified.
As a pedagogue, I'm practicing then. My question is that recently using of UAP against the lawyers, recently the government in 2022, one organization has been banned, and out entire country more than 95 lawyers has been declared as an accused because they were providing a legal aid. So how to tackle this? Because the allegation when I appeared in the matter as a lawyer in Bombay, the allegation was that he appeared for those in a court. That's why he is an accused. So how to tackle this? This is one of the problem.
Absolutely, I have not read anything about it. I can't imagine this happening that lawyer I for you to be accused. But this needs to be tested in the court. Seriously tested.
Even my junior has been accused.
This needs to be tested and it will affect. It's not only affecting legal profession. It will ultimately lead to affecting right to defend and argument.
Exactly.
Because you are declaring lawyers from appearing. But that needs a closer examination. What exactly is the allegation?
Yeah, I'm Shivani. I'm a teacher among the law. You spoke about tendency of cases. What are your views on jury system? Will that help cases faster and reduce the corruption?
I think jury system, if you talk about jury system, it will be a complete violation of principles of fair trial. Jury, they are not trained to appreciate evidence. They are laypersons, they don't know the law. And for good reasons, maybe in anarchist case, we got rid of jury system. Right? I don't think jury system can be controlled.
So, one more quick question. When you said about the say a forest where say what's happening in Sanjay Gandhi, 50 years people have stayed there. So now the courts are looking at what to do with the people. But my question is, can the court actually punish the people responsible to keep the forests intact? Like, how do people get in there? It's never been a question.
One is a category of citizens who have rights as regards the forest. Their rights to protect it. That is one category. One category is the enclosures, staff people. So both the categories are equated together. There are rights in this sort of forest in case of certain tribal government. That's different.
The courts can punish the forest officers.
So I don't know.
Let's not get into it.
So I just need to know.
Sir, good evening. My name is Advocate Jayaprakash Narayan. My question is regarding the Disabilities Act passed by Parliament in 2016. I had a case. The victim was a Down syndrome girl, and thanks to Mirror Law, they came to the rescue. The police was refusing to register the offence because the police is unaware. After the media came in, they showed little push-up and did the research and section 9.
What is your question?
My question is, there is, after the FIR was registered, there was no court in Bombay Session Court. So I had to again write to the Chief Justice, I had to write to the Chief Minister, why is there no court? After 9 months, the court was constituted, Court number 39 Session Court. And then we need to know that the judges, when I appear as a assistant team, the judges are not that sensitive because the girl cannot express, there needs to be sensitivity within the police administration and the judiciary, which is lacking. And I feel so bad about it.
Last question.
Good evening, sir. My name is B.N. Kumar. I run a NGO called Activate Foundation, trying to save your values for deadlines and etc. You are actually very really grateful to you for your judgment on protecting the mangroves. But today, your judgment itself, the danger of getting nullified. You already answered the question for 45,000 mangroves as the age of cut. Another issue is of the compensating plantation. I think it's absolutely opposite because for the mangroves that is being cut in, say, Navi Mumbai or Mumbai, I'm going to do compensating plantation in Chandrapur and Jalgaon. And the absolute no relationship. Here, mangroves are being lost, and I want to plant penicillin trees in Jalgaon and Chandrapur. I think that loss needs to be.
No, but actually, Karnataka incorporated this problem, so we actually said that what is the meaning of compulsory afforestation? A particular area loses the green cover, so that area needs to be compensated. You can't get a distance of 8 kilometers or 100 kilometers. That's the right.
Any last question? Yes.
Ask.
So, good evening, sir. I am first year here and I'm a student from government college. I have a question regarding the pendency of the courts in and Supreme Court. So, we are living in an age of AI, and people's lives are more and more integrated with IT services. So, are there any reforms on that side with the use of AI plus humans in the loop, whereby the pendency of the courts can be reduced to some?
See, AI has limited use. If you supply the data, AI can create a very nice nonsense for you. But AI can't replace human brain. That is a simple example. If you want to cross-examine witnesses in a criminal trial, you have to study the psychology of those witnesses. They are from which strata of society, what is their background, etc. AI cannot be able to do that. If you draft a plane, you have to imagine who are going to be your witnesses. AI will not do. You have to ask the client that you certain documents to produce, whether attesting witness to those documents will support you. All this AI can't help. AI has limited significance, but please understand, I know that AI improves. This custom can be customized to be translated 36,000 judgments of the Supreme Court in Hindi by using an AI tool, or 12,000 judgments of Supreme Court in Bengali. But AI, when it comes to decision making, can give you very prejudiced and discriminating results. So, limited to yes, it will prepare a nice comparison for you, it will correct your factual mistakes in your drafting. That extent, yes. Because even if you are not able to find case law, it will create artificial decisions for you by using artificial intelligence.
Please just request one last question from an NGO Parliament committee.
माझं नाव प्रवीण बोरकर आहे. मी पाणी समिती या ऑर्गनायझेशनचा आहे, संघटनेचा कार्यकर्ता आहे. आपण 2014ला एक जजमेंट दिली आणि त्यातून आज मुंबईला सर्वांसाठी पाणी धोरण अशी पॉलिसी मिळाली. तर त्या जजमेंटच्या अनुषंगाने असं म्हणजे नोंदलंय की घराचा पाण्याशी संबंध नाही, त्या माणसाला पाणी मिळायला पाहिजे हे तर धोरण बनलं. पण त्याच्या अंतर्गत काही वेळा त्याचा चुकीचा त्या जजमेंटचा वापर करून घरं तोडली जातात. तर या संदर्भात कसं
आपली परिस्थिती अशी आहे त्या घराचा गैरवापर होतो. गैरवापर म्हणजे असं नाही, शेवटी थोडंसं नागरिकांचा पण कर्तव्य असतं. एखाद्या जमिनीचा गैरवापर
here to say thank you to all of you, but even more important, thank you to Justice Oka. Because I think what he has done is sort of broaden our horizon in terms of what are the issues which we need to tackle as civil society, activists, lawyers, non-lawyers, and I think there is a lot of thought that we need to give. Probably person like me who is not a lawyer but interested in rights and civil liberties. Listen to his recorded speech again. But I think there are many pointers which have come out through his speech, which requires we as lawyers, non-lawyers, as citizens to act upon and move further. Because otherwise, all of us get so disappointed by various judgments given by the courts, and particularly the higher courts, that people have started losing faith in judiciary. So, at one level, we need to figure out ways of trying to get justice back, and we also need to figure out ways in which we can actually support judiciary in terms of pendency of the cases, or the lower judiciary actually delivering justice, for which we require a basically ground level activism, thinking, and strategy planning. And I feel many of, particularly from the younger generation, would feel encouraged by various pointers given by Justice Oka, and it would be really ideal if people organize themselves, even if they did not come to PUCA, but at least in an organized manner, think of strategies in which we can actually make the constitution work in India. Thank you all.